All right, I think we can go ahead and get this meeting started. Everybody should have received a couple of PDFs in the email. That is one of them is a title sample report, and the other one is a couple of uh, flyer PDFs about how one can hold title, the red flags, and the homeowner's policy comparison chart. So that's what Brad is going to be going over today. So with that, I will give the screen over to him.
Afternoon, everybody. So this is my first time doing the Zoom. I might trying to get the angles right. So Tyler said you guys can pretty much see everything. We're going to be basically going over the title report. I told Lori that I'm going to make it short and sweet. I know you guys all have busy schedules, so I'm going to do what I can to disseminate some important information to you guys to let you know basically things that I am specifically dealing with in the industry right now that are not only delaying or completely failing transactions. So again, we know your time is important to you, and we do appreciate the opportunity to get me in front of you and get you used to me. I'm going to be your title guy, and hopefully, if you have any questions, I would say for project questions or anything that's longer questions, wait till the end of this, and I'll stay a little bit later and talk to any of you who needs or wants to go over something. But again, yeah, Lori just kind of expressed the interest in going over a title report and dealing with red flags, the things that again are causing issues with your transactions and things that you're going to want to look out for. So we'll start with the title report, the sample title report. It's got some notes kind of written into it and some hand notes that I did. So we'll chat about that really quick, and then again, I'm going to go over it fairly quick. If there's a need for a question, chime in. Please just stop me. I have no problem stopping. I know I tend to talk a little bit fast. I'm a fast talker, but again, these classes are for you. These aren't for me. This chance to have a title officer in front of you. So first thing I'd like to say about title reports, they are fairly universal from every title company, whether you're at WFG, CW, First American, Chicago. Our formats can change a little bit, but basically we're all disseminating the same information to you and your buyers and your sellers. So if you work with CW Title, you're gonna get it and you open a listing report and the title report comes out within a day, 48 hours, you're gonna get an email from the title rep who's going to give you a quick red flag review. Those are not meant to be your only time you want to look at your title report. There's going to be things that are out there that your buyers or your sellers may not even know about. So it's important to take a look at your title report in conjunction with the review that the title rep is going to give you, because that will help give you the chance to get out ahead of anything that could potentially delay your transaction. So like I said, we're going to go through the title report. I'm going to stop and tell you about 3 or 4 major stories that I'm dealing with right now in our climate right now. And as you guys know, it's super busy out there right now. So one thing I like to say to all my classes is you guys are our first line of defense in all our transactions. And I say that because you have relationships with the buyers, you have relationships with the sellers. You're going to know about something that we may not know about. A common occurrence that happens is a bankruptcy, where we'll have a seller that's talking to a bankruptcy attorney, and they may bring that up to you. They may not tell you, but you may see some paperwork while you're sitting at the dinner table talking to them about prepping the house and getting it ready for sale. If you see that kind of stuff, it's not inappropriate for you to ask, hey, is there something that you're going through in your life that might delay our ability to sell the house? There's definitely an approach. You don't want to just say, hey, are you going through a bankruptcy? Because that's going to close your customer up right away. But things like that, you guys are a first line of defense, and second line of defense is the title report, which we're going to go over and talk about. So the first thing that we always point out is the effective date of your title report. And I bring this up because it's very important. If you're representing the buyer and you're in the rare scenario where a title report's been sitting for a couple months to even a couple weeks, Some title companies do not update their title reports until the buyers come into play, and then when they close. When we update CW Title, we update our reports every time we touch the report. We look at it and make sure that there's been no judgment filed, divorce filed, bankruptcy, something that could, again, avoid or delay your closing. So that's the effect of the day. And I bring that up when you're getting a listing report from a seller and your seller's agent says, here's the title report, go ahead and look through it. And you see that it's more than a week old, it behooves you to ask for an update, just to say, hey, could you touch base with your title company, whether it be me or another company, to say, did it do a quick, what they call a date down? And that's where we bring the report current to the most recent date. And again, this behooves you because if the seller did file something that they didn't tell their agent about, that could put you down the rabbit hole of you're representing the buyer, they're trying to get this deal closed, they're getting their loan, they're getting their deal approved by the lender, and they're going through all their steps. But what happens if there's something, say, for instance, a bankruptcy that's been filed by the seller? The seller can no longer sell the property without the bankruptcy trustee's approval and the court order. So this could delay your transaction. Something you want to get out in front of so you can share that information with your buyer, because they may have a walk issue, they may have a house that they're contingent upon, they may have to rent a place if the seller can't sell and perform by the contract date. And say, sometimes that's a really good reason or excuse for a buyer to walk away, but oftentimes, what if the buyer really loves the house and they want to make it happen? Getting out in front of these, determining additional costs and time frame are going to be really important. We'll talk about court cases in a little bit. Excuse me. So again, that's the effective date. That's the first thing I look at the title report, just to make sure that it's current. Excuse me. Secondly, if it's a listing report, you won't have your buyer information, which is the proposed insured for the homeowner's policy. So I added the two flyers that Tyler mentioned, the how one can hold title and the homeowner's comparison policy chart. I only jump to these flyers really quickly. We're not going to go back and forth too much, but these are great tools for buyers. Buyers who don't know what they're getting and don't know why and who's paying for the homeowner's policy is covered in this comparison chart. And there's the three columns that they will always be the same. This stands through for all title companies. You have your standard owner's policy. You have your homeowner's policy, which is the ALTA. Everybody refers to the ALTA. And you have your extended owner's policy. So when you're looking at the title policy that is being offered, if it's a listing report and it's a vacant piece of property, you're not going to get the ALTA offered. It does not qualify for the ALTA. It only qualifies for the standard. So one thing you want to look at as you open your title report and you see that first, whether you have buyers in it or not, it's going to tell what the title company is offering at that time for that policy. Typically, the default is the ALTA on the purchase and sale agreement. But one thing to watch out for on Form 22D, which gives you the option to click choose which title policy, they refer to the ALTA as the standard in one spot of that, but we also have a standard owner's policy. So you really want to watch out for that when you're checking it on a buyer's contract, when the contract's been completed and offered to you and represented the buyer. Form 22D, if they check box 2D, they're asking for less coverage, or they're offering less coverage.
And just to chime in there, Brad,
yes.
If you just leave that section blank and don't check either one of the standard or the extended, that is going to give them the then current form, the ALTA homeowner's policy, which is the best form, if that's correct.
Right, absolutely. And then the reason why I also bring it up too, yeah, correct. You definitely don't want to do anything if you're representing the buyer other than review it, because some sellers do check that box, and what they're telling you is they are not offering you the full expanded coverage to your buyer. That's not necessarily a red flag, but it could be. So if you see a seller check that box, call your title company. Say, hey, Brad, why do you think, why is the seller not offering me the best protection for my buyer? call me, give me a call, I'll take a look at it. Whether it's mine or not, I'll take a look at it. One common reason for that is that it's a REO lender who's had to foreclose on a property, and they're reselling the property. They've already lost a bunch of money, so they're not offering it for cost reasons. Another reason that's common that's not a red flag is when a builder's offering it. Most builders know now in this environment, if they don't offer it, they're basically scaring a buyer away by offering less coverage. When I say most of them do know that, and they offer the Alta coverage, which is the best for your buyer. So again, I'm only jumping to this to accentuate that point because it's really important for you to look out that for your buyers. Excuse me, frog in my throat. This is also a great tool for, and I'll only bring it up shortly, the extended owner's coverage policy. Most residential real estate agents don't deal with the extended owner's policy. It's typically reserved and used for commercial purchases. Lawyers are involved, so they're requiring their buyer to get the extended when the extended lenders involved. For a residential sale, in my experience, I've dealt with maybe 2 of these in over almost 20 years. And one of the reasons is the buyer's responsibility is to provide the title company with a Alta certified survey. And King County, on a typical 2,000 to 3,000 square foot lot, you're looking about $3,000 to $4,000 that the buyer has to pay for. And right now, in the environment that we're in, with everything so crazy, busy, and saturated, you're looking at about 6 to 9 months, if needed, depending on the survey company. And then the buyer has to pay these extended coverage surcharge, which is thousands of dollars, and that's depending on the sales price of the property. And so what I tell people when they ask me, and we got to be careful not to give your customers real estate advice. Excuse me. With all this extra coverage that the buyer is paying for, the survey costs, the extended coverage, the time frame that they're having to wait, potentially paying lock extension fees, they're basically, by giving us this survey and paying all this money, they're asking for less coverage. And it's pretty easy to see all these X's that the homeowner's policy, the Alta, is getting compared to the extended owner's coverage. They're not getting all this extra coverage. So they're paying all this extra money for less coverage. And the reason why it comes into play is because it's more liability for the title company. So we're saying, yeah, we'll give you the extended coverage. We give some, there's a couple other items, but again, they're more reserved for commercial, so I won't get into it. So we're done with this flyer. But again, it's a great one for your buyers, and we have hard copies that we can send out to your office. But yeah, the buyer is basically paying more for less coverage. So that's why I typically say it's not worth pursuing. But if they have an attorney advising them, or someone says they should get the extended coverage, send them to me. It's one of those scenarios where I'm not going to talk them down, but I'll give them the reasoning why it's not used, and then I'll let them make their decision at that point. Most buyers, for residential, I've never, like I said, I've seen it like twice in 20 years, and it gave them less coverage. It never became an issue, but it just sat. Okay, so we spent a lot on the first page of the title commitment because that's where a lot of the bulk of the information is. So one of the things that title companies don't get all the time is a copy of the actual purchase and sale agreement. A lot of times we'll get transaction coordination sheets. So when you get your buyer's report, you're definitely going to want to look to make sure we spelled the name right. Anyone did? I mean, I'm assuming here that some of you have dealt with ID statements. Thomas Jefferson can be spelled with an S-O-N. It could be spelled with an S-E-N. You can get a Thomas with an H, without an H. These items, these variations in the names, spelling of names, can determine how long it's going to take for us to search the property and clear your buyers or even your seller's names. So if we have wrong spellings, this is your opportunity to say, hey, Brad, you spelled my buyer's name wrong. Can you make sure that there's no issues? Or, hey, Brad, same with my seller, or if my seller's passed away. This is your time to tell us, hey, looks like George Washington is alive, but Martha's passed. we may not know that. This is your time to jump out and let us know what's going on in your customer's transaction. Any questions while I'm on the first page still? Okay, I'm just gonna keep going. Chime in if you have any questions. I'm pretty laid back. Lori will tell you. I enjoy my job, and it's about making sure your transactions get closed and not delayed. Sales price pretty important in that we got the right sales price. If there's a variation in this and you're dealing with a short sale lender, you're gonna have to get us notice right away so we can update everything, because a change in a fee could change the short sale approval. It could reset you. I've seen it reset over $100. So be very careful throughout your transaction to let us know if you're in a short sale. Keep escrow price, let us know, because any change could reset it. So typically they're approved ahead of time, and by the time we get to this process, everything's being dealt with. Payoffs are in hand, so we're pretty good at that. Next one, we have the sellers. Again, this is going to tell you who your sellers are. So if you're a buyer's agent and you get a title report and you see a different person, or you see someone else, there could be a very reasonable explanation. You could be dealing with a power of attorney. You could be dealing with an heir. But a lot of times you don't know this until you get the title report, what title is telling you that we're going to need to do to close the transaction. This kind of leads me into my first big story. And this is an example of something that I deal with on a weekly basis, not to this extent. I've called it my fish story. I know Lori's heard the story. I think Tyler has as well. But we had a seller called the Fish Company. We'll call it the Fish Company 1. They were selling a piece of property, and this is back around 2008 or 9, back when title reports were sitting. You had a property go on market, it would sit for a while. Well, in this case, it sat for like about 6 months. Buyer's agents come into play, and the buyer's agent happened to be a buddy of mine. And he says, "Hey, Brad, I'd like you to do a quick title review for me." Gave me a call, gave me the title. I looked up the title report, reviewed everything, looked pretty good. And what I did notice is that we had the Fish Company LLC that was in title. So the first thing we did when title went out 6 months prior, the title rep gave our red flag review, said, Fish Company's in title, they owe Bank of America $100,000, and title is asking for a copy of their LLC agreement. So that will be in our title report. There'll be a paragraph, we'll come across it. I'll blow by it since we're doing the whole story on it. But title is asking for a copy of the LLC operating agreement. And normally I ask if does anyone know why we ask for that? The reason why we ask for that is because we need to determine who can sign on behalf of the company to your new buyer. And we gave the listing agent the heads up. They talked to him, gave him the notice. Listing agent said, "Fine, I'll get that if you ever, no worries. We're not in a rush. It just went on the market." Fine. Sat for about 6 months. Like I said, no one said anything. Listing agent never followed up with their seller. My buddy calls me, as I said, looked at it. I said, "Hey, looks like we need to call that Fish Company LLC. Let me give him a call." I gave the listing agent a call, said, "Hey, this is Brad. I just want to remind you, we need a copy of that LLC agreement." The listing agent said, "Great, fine. I'll call my seller. We'll get back to you." About a week went by. We're in contract at this point. My buddy gave me a call again. He said, "Have you heard anything? I haven't seen a title update. No one's told me whether we're good on this or not." I said, "Let me check." Gave the listing agent a call again. Sure enough, he said, "I apologize. They were on vacation or business trip." I can't remember what it was exactly. This is a couple years ago. I said, "Okay," explained to him again why we needed a copy of the LLC agreement. He's like, "I totally understand, Brad. Thanks for reminding me." Sat for another week or so. My buddy's now the other day at this point saying, "Hey, Brad, where are we with this? Where are we? We need to get this. I want to make sure my buyers can move into this house." Well, finally, a little bit later, a couple days later, I finally get a hold of the seller. I talked to the agent, and I said, Agent X, can I call your seller and talk to them, because I need to convey some urgency in order for us to get this property sold. Agent said, "Fine, give my customer a call. I'm happy to do so." Something that title companies don't always do. We're not going to reach out to your customer because it's your relationship with them. We're going to talk to you first and ask you for that permission. So I got a hold of them. He said, okay, fine. I'll get it for you. Sorry. I know my agent's been asking me for it. Shoot to the next couple of days and nothing back. Well, the seller decided that it would be a good idea to go on vacation. I know that, and they were gone. We were closing. This is on a Friday. That they're trying to close the next Wednesday. We don't have anything back. Everybody's a little bit conservative. And then finally, I get a copy of, they were able to get a hold of the attorney who had it in a locked cabinet in their office. We were able to get the paralegal to go in, or the partner to go in, get us a copy of the Fish Company LLC. In that LLC, the managing company of the Fish Company LLC was Fish Corp. My pen, that's that. So we'll just say Corp, Fish LLC 2, and Fish Trust. My handwriting is arcane. You don't need to know it too often. I just use it for like the separation. So we'll set the corporation aside really quick. Dealing with Fish Company LLC 2. So I'm great. I've got all three of these 100+ page documents in my hand. We're trying to close, it's Monday. We're trying to close on Wednesday or Thursday. I'm reading these documents, and in Fish Company 2, the managing member of Fish Company 2 is Fish Company 3. So we now have a third document I need to look at that the attorney and paralegal could have gotten to me all at once, but they didn't. Then I jump over to the Fish Trust, was able to clear it up. We found out who the trustees are. They layered their own assets to their personal reasonings, and that's their prerogative. We're never going to question that unless they can't provide documents. It becomes a little bit of a red flag. But keep in mind, we're almost at the 0 hour. I'm trying to get Fish Company LLC. I finally get it. People have been calling the paralegal because, again, the attorney's still gone on vacation. The paralegal or the partner, I think it was the partner that eventually got me Fish Company 3 LLC. And when I looked at it again, of course there was another LLC. We're now layered upon layered upon layered. And again, we don't question that. That's their prerogative. And this is something you want to talk to your customer about when they have a trust, an LLC, a corporation, or whatever those documents. You're going to want to ask them, Brad, get your title officer, everything at once. At this point, I can only guess, and I'd say this kind of tongue in cheek. I hope that this never comes back to me, but this attorney know what's going on. They knew we needed this. They knew we needed this. They knew we needed this. And they knew we needed this. They also charged our seller for every email, every fax, every different interaction when they could have gotten it to us all at once. I don't know if that was intent by their intent, but they did because I heard about it. That's how I know. So anyways, long story short, just gonna cut it down a little bit. Cleared. And it was all the same people. It was all this big kind of conglomerate that was hiding one asset. It happened to be the owner of the company's personal residence that we're dealing with, and that's why I'm involved in. So setting all of this aside, we got all this cleared, jumping back to the Fish Corporation, where the night before closing, they needed to close. This was the last asset of the Fish companies. So they didn't to reinstate this corporation before it expired. And because they layered everything so deeply, my boss had them drive down to Olympia because they couldn't do it. This is years ago where for whatever reason, they couldn't do it online same day. So they had to drive down to Olympia, pay their reinstatement fee, give me a receipt, which then allowed me to, for John Smith to sign on the Fish Corporation. So basically, all in all, we only had 3 different people signing for all these different entities, but the way they layered it in our, we have, in our doing our due diligence to protect the seller, protect the buyer from any future attack. Because what if we didn't make them reinstate? Someone who's involved in the corporation could have come back and said, you allowed for someone to sign on behalf of a corporation that was no longer in existence to sell a piece of property. I was part of that corporation and I didn't get any money. I'm suing you. So that just an example of why we go through this. So this is like one of my biggest and longest stories, because when I say I deal with it on a weekly basis, it's weekly, not to this extent, sometimes to this extent, because people write up their own agreements, their LLC agreements, their trust agreements, to basically set in a checks and balance scenario, so one person can't sell a place of property without everybody else joining in or being part of that. So while I erase this kind of goes to the next flyer, the only other flyer that I'm going to make you look at, the how one can hold title. This is a great flyer because it tells the buyer what happens in certain scenarios. So again, these flyers we have available for in like PDFs and pretty colors, but to do basic is the main ways that people can come into title. And I bring this one up specifically too, because back to when I say a lot of title companies don't read the purchase and sale agreements, a lot of those purchase and sale agreements don't have all the drop-down options in the new electronic form, so it gets left blank. If you send a purchase and sale agreement to a title company that has blank or indeterminate, like John Smith, but with no marital status, or John's company, or the Richmond company, but not telling us what kind of company it is, we're going to have an issue. We're going to stop and we're going to be like, hey, I need to know, because the certain various ways can affect how we deal with title and how they purchase. And a lot of it comes into play when someone's borrowing money. A lot of lenders don't lend it to companies unless it's specific, their business division for residential purchases. There's something going on, and so most lenders make them do a different structure, so I'm not going to see it. If someone comes in married as their separate estate, we need to know that. If you don't tell us that John Smith is married and we have a contract with John Smith and we run John Smith, and we kind of talked about ID a little bit, clearing John Smith's name against the public record in King County, there's 55 pages with about 20 items each. So if we know about John Smith up ahead, we're going to tell you we're going to need what's called that ID affidavit or statement of identity that you'll get from your title companies to clear the buyer or the seller's name. If we don't know that John's married to a Jane Smith and we get to all the way to closing, we're going to have to delay your closing. We could, I don't want to say I have to, but we could have to delay your closing. We're going to do everything that we can to avoid it. But if it's the last day of the month and someone's telling me about a Jane Smith that's coming into title, or a Jane Smith that's on title that no one told us about, these are the types of red flags that we like to jump out and get ahead of. But again, these are the ways that title people can come into title: committed property, tenancy in common, trusts, joint tenancy, as a separate estate. And why I say it's a great tool for the buyer, because it tells them what happens in certain scenarios on the left side. So I'm going to talk about one more scenario, one more quick story for joint tenancy. If you have buyers that are coming in joint tenancy with right of survivorship, I bring this one up because if you don't tell the title company, we don't know to tell you about our requirements for them to do so. Joint tenants and right of survivorship, I'll deal with it with two people. It could be two or more, but you have Brad and Brad's brother, Jeff. So if I'm buying a house with my brother and we want to come in joint tenants with right of survivorship, basically that's saying to the world, if I die, my estate for this property automatically goes to my brother. And if my brother dies, his half of the house, we're not talking about our whole estate, just the estate for the house, goes to me. And this is important because one, it survives, it's basically estate planning, and it survives in court should the heirs. So if, say I pass away and my wife wants half my estate. So she wants half of the house that me and my brother bought together as joint tenants. Well, she's going to sue my brother, and my brother is going to say, no, I came into title of that special joint tenants with right of survivorship way. And the requirement that's important for you if you're representing a buyer that wants to come into title this way is that the requirement is for the buyers to additionally sign the deed. So in your typical purchase and sale, the seller signed the deed, the buyers sign their loan docs, all goes to title, and we record and close once all the funds are in. In this special way, and I bring it up because it's hit me a couple times this year where no one told us. Buyers, brothers and brother and sister brother were coming into title, joint tenants in title, joint tenants with rights of survivorship. And the additional thing is, again, the buyers, after the seller signed the deed, that deed now has to travel to the buyers. And I bring it up because if the buyers are out of town, if the buyers are in another state, you have additional travel time. And with everything going, everybody's pushing closings, trying to get to their closing right away. What's happening is buyers, you need an extra day. But what if your lock is expiring? What if it's a Friday and that extra day is the next Monday? Now you have 2 extra days and they're planning on moving into their house on Friday. You potentially cannot do that. A title company will not insure it with that additional coverage or with that additional signature. Now the buyers can come into title the way they want or the other way to get their file closed. But what happens if one of them passes away and an agent tells them, I've seen this, just go into title the regular way, which is tenants in common where you each hold 1/2 interest. Well, that's great until one of them passes away. And I'm not trying to be morose in the passing of one, but that's great until one passes away and the other not realizing what they just did to their half of their interest in the other house, their brother's house or friend's house. They now have no right or claim to that. And I've seen some scenarios where a lot of money has gone to court because brother A, brother B bought a house to work. They put all their money in it, their nest eggs, rehabbed the house, tried to sell the house. Brother A passed away. Brother B went to claim, sell. Brother A's, what spouse of a deceased partner is not going to make a claim on their estate? We had a $300,000 claim on a $700,000 house. So I spent a lot of time on these first 2 flyers and this first page because it is the meat of your title report. If we get this wrong, we could screw up the whole deal. So look at your title reps, title review. Talk to them if there's something wrong. And then if you're working with me, you'll most likely have my email. My email should be in what's there. Give me a call, talk to me, let me know what the situation is. That allows for me to get out ahead and help you close your transaction. Yes. Oh, thought I heard someone. All right, so that's the first page. Any questions on the first page of the title report? Again, spent a lot of time on it. So I'm gonna move on real quick. Okay. Next page, pretty straightforward legal description. Only thing I say about legal descriptions, regardless of the title company you get your exhibit from or your profile, your trio, or whatever title company calls it, always match it up to your title report after you get your title report. Because most of the departments that are pulling you your trios, your exhibits, your listing packages, they're the customer service department. They're not examiners. So they're basically giving you the last deed. There could have been changes since that last deed. Say if the last deed was from 1967, you get this old deed that you can barely read and you're like, well, what the heck does this do with me? I'll have the title company type up something great, but you still want to match up your legal description to your title report when you get it. Because otherwise you could have a bad exhibit and it may not kill the deal, but it could delay it if you have to have a new addendum done and everybody's got to sign it off. And if you got a seller that's out of town or a buyer's out of town, yeah, it behooves you to match up your legal description because it's really important for that to be reviewed. Next, we go to the special exceptions. I basically blaze by the requirements. They're just standard things. If there's questions, you have my information. I'm happy to talk to you about them. But I jump into the special exceptions because they're the meat of the title report. And what a lot of people don't realize about special exceptions, they are that. They are exceptions to the buyer's title report. So if a buyer has a issue with an exception on title, this is their time to review it and talk to me. This is their time to have you give my number and have them call me so I can go over an exception with them and talk to them. Whether, and again, it's not my prerogative to make them want it or make it, but it's my prerogative to help them understand it because they need to know what they're buying subject to. And an exception, we'll talk about a little bit of those. So first one, I just moved past really quick. It's real estate excise tax. Who pays for that? Sellers pay for that. Why do the sellers pay for that? Because the sellers are the ones, through you, who contracted me, the title officer, to ensure the sale. And that's why sellers pay for title insurance as well. So buyers pay for, I jumped past the buyer's lender loan on the first page, but if there's a loan, the buyers will pay for the lender's title policy. And the reason why that is, a lot of people ask me, why am I paying anything for title insurance if the seller's paying for my owners? It's because the lenders basically say, I'm giving you $500,000, $200,000, however many hundreds of thousands of dollars to buy this piece of property. You are going to pay for my title insurance. It's just a cost they pass on to the borrowers. So if they're lucky enough or they're in a scenario where they are buying cash, their estimate will not have a title insurance premium because they're not paying for any policy. Excise tax, to pass by that one. Jumping into property tax, pretty straightforward. If you're selling a piece of property and you see 3 full years, this is a huge one. If you see 3 full years of delinquent taxes, that tells you need to call, or your seller needs to call the assessor right away to find out when the next tax foreclosure is. And the reason is they're not publicly posted like your deed of trust foreclosure when someone can't pay their mortgage. A tax foreclosure is a different public auction. It's separate. They do it different time frames. And that tells you, if you see 3 full, if they don't check and find out for sure and confirm that they're not on the next roll, you could be putting a lot of work in a listing and a sale to get a property ready to sell and have the property sold out from underneath you and waste a lot of your time. So if you see 3 full delinquent years, we give you a number. We should always give you a number. There should be a good number in there. It's not in this paragraph, but if it is, we'll tell you what it is. And then they need to call the assessor. And if not, call me. I'll walk you and your customer through it. Any questions about taxes? Pretty straightforward. I'm not going to get into some of the ins and outs other than, if there's senior exemptions, a lot of buyers want to know what their prorated amount is. Give me a call. We'll give them an estimate. It's going to be within a couple $100. It's not going to be exact. It's just something that they'll have to expect. One call I get very often is from a buyer saying, well, I'm moving in October. Do I have to pay for the full half or the full year, whatever, depending? And I say, that's an agent question because it should have been addressed in the contract. If not, you need to get it taken care of now because when we get to close, it will be your responsibility if not addressed. So pretty straightforward with that.
Can you please explain the excise tax again?
Say that one more time, please.
Can you please explain excise tax again? I didn't realize that the seller is paying for it because they're choosing the title company, you said?
Not not because they're choosing. Sorry, I may have misled you there. The seller is paying for it because it's sales tax basically. The seller's paying for the title policy because they're contracting us.
Right, right. And excise tax is just a tax that they have to pay.
Right. All sellers have to pay. It can be negotiated if there's a closing cost negotiation addendum in there, but typically the seller is the one who pays for the excise tax. And I don't know if you guys know or not, this year it went up. It used to be a flat rate across the counties, 1.78 with the exception of about 2 or 3 cities in our area. Now it's based on the sales price. And if you're dealing in houses that are under $3 million, it doesn't really affect you as far as the scale. But once you go over to 3 million, it's exponentially more expensive. So if you're dealing with that, give us a call. We can give you an idea. We have calculators. I don't have one here, but we have a calculator that can tell you right exactly what it's going to cost your seller. But yeah, it's exponentially. If you get into $10 million, you know, and above, it's like, I saw one for like $70,000. So it's a significant fee that they're going to have to pay. Did I answer your question?
Yes, thanks.
Okay, of course. All right, so CC&Rs and easements. I'm not going to get into all my CC&R stories. I could tell you for a long time, but I want to get you guys out of here. I am going to tell you about an easement story that I'm dealing with that's huge. I've got an agent that has a $3 million house. It's on the water. In 2006, they found out that the neighbor's house encroached onto their property. I'm just going to give you a little bit. And they were encroaching onto the neighbor's property over here. So the neighbor's house comes down onto our property. Our driveway goes up onto their property. This is an agent of mine. I've been working with them for 20 years. They went into this agreement in 2006 to do a boundary line adjustment, but they were good neighbors. He didn't care that his house was over. It wasn't an issue. And a lot of things where people don't understand for encroachments and easements, if it's an issue, it could be an issue. If it's a perceived issue, some people don't, especially with their amicable with their neighbors, they don't care as much. So we've got encroachment of the house, encroachment of the driveway. 2006, they were planning on doing a boundary line adjustment. They never did. Jump to 2019, end of 2019, they opened title. Oh, forgot about the encroachment. Never dealt with it. Jumped to a month ago. They're like, well, we've got it sorted out with the neighbor. We're gonna do an easement. And I said, okay, let's see it. What are they going to do? Basically, the easement was for top property to allow, bottom property allowing top property to encroach. Top property allowing bottom property to use their property. Great. They were going to get it recorded. It was going to be fine. Well, this is a $3 million waterfront piece of property. I have a buyer that rejected the easement and said, no, I want additional coverage. I want more assurances that they'll never attack me and then I can never attack them in a court case. We said, okay, well, they could do a boundary line adjustment. If you do a boundary line adjustment mid-transaction, just let me tell you, you're looking at months of extra time on the property. We gave them the option of the easement, but the buyer didn't like it. The buyer just walked away from the transaction because the seller didn't have the encroachment issue satisfied to their satisfaction. So I bring this one up because this is a story that could have been dealt with years ago. B, to get an easement recorded. So this is either during or after your transaction. If your buyers want to give an easement, one thing that buyers don't understand or owners don't understand is once you borrowed money from a lender, you can't give an easement to anyone. They have what's called a due on transfer clause. And so this is adding another week or two to my transaction that I'm dealing with right now, because this neighbor is trying to sign our easement to make everybody happy. Seems pretty reasonable. Well, this neighbor owes $100,000 to Bank of America. Bank of America any lender has what's called a due on transfer clause. So I bring this one up. So if your buyers are talking about doing something after they purchase, be very careful and have them call me if you hear anything. Oh, I'm going to put title into my trust. Oh, I'm going to give my neighbor an easement. Oh, I'm going to bring my girlfriend on the title or bring my kids on the title. They cannot do that without getting their lender's permission. Because if the lender finds out, they can come to this guy who signed this easement to allowing for our buddy to have this property or use of it, Bank of America can come in and foreclose on the property because they violated their contract by giving an interest away. So this is a huge one, and I've been seeing this a lot happening. So if we don't get Bank of America to approve the easement, they can come foreclose and wipe out the easement. So anything that your buyers are talking about, or even seller mid-transaction, if they don't get the neighbors neighbors lender to join in on it, they can really screw themselves over. I had one, just same exact situation. Basically, neighbors just gave each other a little bit of piece of property. They went and did it. They recorded it. So we'll just say top property had BOA 100K. So they recorded the easement. So now this property has a little bit of this property, or excuse me, they did a boundary line adjustment. So they switched it. So this property owns some of theirs, and this property now owns a little of theirs. But because they didn't bring the lender into it, the lender didn't sign off on it and release it, this property, who now has this little portion of the property, now has Bank of America's loan on their property because they took a portion of their property without checking with the lender, and now they have their loan on their property. And this is an agent that did this. They did it. They were amicable with their neighbor. This like, let's change the property line. We'll work it all. Now I have a little bit more space for my driveway or whatever was the scenario. They did it. This happened a couple years ago. No one knew about it. Agent now is going to sell his piece of property, calls me for a title report. I said, oh, yeah, you have their loan on your property. Did you get a release? Agent says to me, I don't know what you're talking about. Why would I need to do that? That's my kind of red flag story. So anytime you hear anything from the neighbor or your buyer or your seller talking about an easement or doing something, give me a call. Have them give me a call. Tell them what they need to do to get there, so it won't affect their ability to sell. Next page, just jump into the deeds of trust. We've got pretty straightforward when you see a deeds of trust. Part of your red flag review will include deed of trust, Bank of America, X amount of dollars. All you really need to know about that and look at that part of the red flag of review is if you have multiple deeds of trust and what they're trying to sell the property for. Because you want to make sure that you're not getting involved in an over-encumbered property. It's possible, and it doesn't mean you can't sell it, but if you're in an over-encumbered property, you're now kicking into a potential short sale. So you're going to have to deal with those matters as well. So always add it up, and then some of them don't say it, but they might be lines of credits. So John could have a line of credit for $100,000 for Jane's first year of college, or not 100,000, but 20,000 or whatever. They could have 15,000 out there for a boat or whatever the situation is. Talking to your customer and finding out what the situation in their life is going to help get out in front of issues. So really, that's the big thing I bring for red flags for that. If you see a notice of trustee sale, this is another one. Look at the sale date, because if the sale date's coming up or close, or I even say within a month, you need to stop, call me, and I'm going to give you the trustee's information, because you need to find out when they're gonna, what this trustee is gonna require to forestall a foreclosure, and usually the answer is money. So if your seller doesn't have whatever it is, they'll usually say on that document what they require, 20, 30 grand. If your seller can't come up with that money, some trustees negotiate and they'll take a little bit less for, because most lenders aren't in the business of repossessing. They're in the business of loaning and making money off their loans. So you might get a lender that's a little more amicable and willing to work with your seller, but they need to get up in front of that right away, so you're not wasting yours and their time. Any questions about deeds of trust? Pretty straightforward there. Again, I'm flying through this, guys. I'm not in a rush to get out of here, and then you'll have my contact information. If any questions come up down the road, I love answering, and I love helping people, solve their problems here. Judgments, mechanic liens. We'll talk about those real quick. If you see a recorded judgment, typically just ask your seller or your buyer, is it theirs? Are they aware of it? Have they paid it? Sometimes they don't get released, and it's just a matter of it getting taken care of. The only scenario I'm going to bring up to you is the bankruptcy situation. I had a file, we showed a judgment. The seller told their agent that it got taken in their bankruptcy, showed the agent the bankruptcy paperwork, but the agent never called me. Recorded judgments are dealt with a little bit different. When you go bankrupt and you hire an attorney to file bankruptcy proceedings, whether it be 11, which is restructure, 7, which is a complete wipeout, and 13, which is a payment plan. When you get discharged of the debt, basically you go through, you fulfill all the terms of the bankruptcy proceedings, you then get, as a debtor, get discharged of the debt, meaning that lender, ABC, Ford Credit Union, I shouldn't say Ford, but you know what I mean. They can no longer go after you as an individual. That creditor, Ford Credit Union, ABC Credit Union, records that judgment. It has now attached to the property as well as the individual. So if it's done before the bankruptcy proceedings start and ABC credit holder is smart and they record it, they've now attached it to John Smith and anything John Smith owns as far as real property. And so this is common. Debtor who went through the process, got removed, got the judgment removed against their self as an individual, didn't realize that there's additional steps. So this is kind of my last one I'm going to put at you. I think we're coming up on time pretty quick here. It's huge. Call me right away, because here's the options. I'll tell them, but call me right away. One, they can have their bankruptcy attorney reopen the bankruptcy proceedings, give notice to ABC creditor, wait 20 days, get a court order to what we call avoid the lien against the property. They're already free and clear against their debt, but a lot of people think, hey, I don't owe that anymore. I don't owe that anymore. You can't mess with me. I'm free and clear. Not understanding how real property works in Washington State. That's how creditors get their money back. They're able to go against a person and go against their property. And most people, when they sign the credit card bill or they sign the whatever, the car payment, they're also giving that lender the ability to lien their house if they don't pay. So, you know, we all have our scenarios, and I'm not judging anyone, but we also have to do our due diligence, because if I close a transaction and we haven't dealt with ABC's $100,000 or $20,000, then it's on us and we get sued. So that's why you're going to see title companies stop and ask these additional questions on the bankruptcy. If someone says, oh, I got taken care of my bankruptcy. A lot of debtors don't understand the additional. That's where we come in. And that's why when you hear about a bankruptcy or you hear about that's your key to call me. Hey, Brad, Joe said that he might have filed bankruptcy in another county, another state. Bankruptcy's federal. When you file bankruptcy, it freezes everything. When I first started in title at CW Title, it was 15 years ago. I was in the break room and I was reading a sports paper and I saw that ABC baseball player had filed bankruptcy in Florida. And I knew ABC sports person. And I was like, wait, we have an open order with this guy. We're doing a refinance here in Washington State. I go to my boss and I said, hey, what do we do if he's filed in another court? Nothing. We have to stop. And if you call me, that's disclosure. If you hear about it, you see it, you now know about it. You cannot sell, cannot refinance a piece of property without a court order. And then the last thing I tell people, and this is one of two things that I ever tell people in any of my classes to write down. Lori knows I'm pretty lax with that, because I like to consider myself your tool. Just call myself a tool. Bankruptcy. If you see a bankruptcy on your title report, we're going to tell you. Paragraph 16. There's two 14-day appeal periods that could affect your purchase and sale. So if there is an off court authorization to sale, I'll say in our paragraph, great, you're good. You can close whenever escrow is ready to close. If there's not, you potentially have 28 days from the court order approving the sale. 28 days before you can close your transaction. So if it's been accounted for, great. Everybody knows that there's a time frame. Most attorneys are going to be telling their sellers this, but as we all know in our life and working with our customers don't always tell us everything. So they may not impart that to you. So if you represent a seller and you don't have a court order, call them, ask them, say, what's the status of this? Because that will allow for us to get out in front. There's 14 days and there's separate appeal periods. One can be waived by the court, which a lot of attorneys are savvy and do that because that allows for the ability to sell and up your ability, up the time frame. And then one's a creditor's appeal period, and that's as a title company waiving situation. So if you see bankruptcy, call me right away because I'm going to have to look at everything. I'm going to ask for the kitchen sink, and from there, if we get ahead of it, I can put everything in front of my underwriter, get approval, and get you a firm day of closing that we can adhere to and go through. So that's kind of it. That's kind of my quick red flag run, guys. I'm here for you. My information, I believe, is in the original email. My name is Brad. It's been a pleasure. This is the first Zoom class, so it's a little weird looking at my picture of myself the whole time. Does anyone have any questions?
No questions. Just want to say thanks, Brad. It was awesome getting to watch you and your information. And yes, I remember the fish story. It was really great. I loved how you went through so many different parts of the title report. So hopefully everybody got a lot out of it. There was 18 people off and on during the presentation. So we definitely got the information out to a lot of our brokers, which is awesome. And yeah, I just want to say thanks.
Yeah, you're welcome. And yeah, if you share my information, again, if anyone has any follow-up questions, I'm gone for the rest of the week. I'm off today and tomorrow, so I'm just dropping by to say hi and do some time.
I know, and you came in just for us. Thank you.
All right, guys. Thank you.
Thank you.
All right, Lori, I'll talk to you in a little bit.
All right. Bye.
Bye.